Okay, I wanted to take a minute to explain how I read Roper versus Simmons and how the case is organized. This is going to help you understand what we want from these IRAC sections when you write a brief or when you write a memo, because I want to show you where those pieces are in the court opinion. And when I was asking questions about the analysis or why the court did what it did, I want to show you in the opinion where that is so you can get used to finding it. And the first thing I want to point out is that there's some language in this case that might be confusing. That's because this is a habeas corpus case. Christopher Simmons, in the caption here, he's our defendant, and Roper is the superintendent of the correctional facility where he resides. That's because that's how habeas corpus is filed. Once you've finished all of your general appeals, all of your direct appeals, you can have a second bite at the apple, and it's a constitutional case that says you are holding me, superintendent, correctional facility warden, you are holding me unconstitutionally. Everybody else screwed up, and therefore I am being held here unconstitutionally. Let me go. So when we see these cases, it doesn't mean that the superintendent personally did anything wrong. It's just that that's the way it's filed. So when you see the language that refers to the parties and refers to Roper, that's who that is. We also know from this caption that Simmons won below in the last case. And that's because we always put the moving party or the appealing party or the filing party first. So when they say petitioner in this case, they don't mean Christopher Simmons, they mean Roper, they mean the government. Here it's not, he really is a stand-in for the state. So in that aspect, when you see the word petitioner, they are talking about Roper because Simmons won at the last level of court. He doesn't need to file anything. So as I scroll down and I show you the organization of this opinion, you can follow along with this little button over here on the left-hand side. Some of these things here might be helpful to you, but I'm going to scroll all the way down until we get to opinion so that you can start looking at how these cases are organized so that you can use it to your benefit. Because remember, when we have someone that we want to argue for, we need to say, Judge, my client's case is close enough to Roper versus Simmons, so you should follow it. Okay. Here's the beginning of the opinion. I've gone through and I've charted out the organization of this. This first paragraph is just a little intro, but it gives us our issue. You will see IRAC formation. This case requires us to address. It's what the case is about. The question is whether or not he can be put to death because he was under 18 but over 15 when he committed a capital crime. That's the issue. Now, it doesn't go right into the rule. It does give us a little factual background. Remember I told you sometimes you can do an IRAC brief or you can do a FIRAC brief. That's essentially all this is doing, is it's bringing in a little of the facts. Also, in a judicial opinion, we do see more of the facts than we will in a brief that you or I might write, because the facts matter a bit more in that context because they are actually deciding this for this guy. If I'm concerned about the law and I want to use this case to represent another guy, the facts aren't as important as we discussed in class. So for that reason, we do see this factual breakdown here. That doesn't necessarily need to appear in our briefs because we are briefing the law, the rationale, the analysis. So number one is just a factual background, and it gives a tiny little background about the law because it tells what the arguments were in other courts, because there was also another legal argument here, ineffective assistance of counsel, that was gotten rid of. And now we are here based on Atkins. It's telling you this in the introduction. So we've gotten the facts. We've gotten the issue. What's next? The rule. Section 2 gives us the rule. Section 2 goes all through what the law currently is, and it talks about the 8th Amendment, the 14th Amendment, Thompson, Stanford, Penry, which is not something we talked about in class, and Atkins. So all this Section 2 here is doing is it is giving us the rule. Section 3 goes on to legal analysis. There's an A and there's a B. And before we go into what this court opinion says on it, I want to give you a tiny bit of background. There's a saying that the Constitution gives us a floor and state law gives us a ceiling. What that means is the Constitution, the federal Constitution, gives us some basic constitutional rights like due process, the right to an attorney, the right to remain silent, the right to bond or reasonable bond. All of those things are the floor of our basic constitutional rights. States can give us more. States can build a 9-foot ceiling. States can build a 10-foot ceiling or a 12-foot ceiling or a 4-foot ceiling, but they cannot dig a basement. States cannot take away those rights. So when we see that the previous standard of the law in Stanford and Thompson was that we could, it was constitutional to execute 16 and 17-year-olds. Many states decided to up that ceiling and say, we're not going to do that. We're going to give our 16 and 17-year-olds in this state more rights. That is possible. And without that background, it makes it a little more difficult to understand this opinion, but hopefully that helps. So now we get into the analysis. We know what the law is. It's Stanford, it's Thompson, and we'll get back to it in detail in a minute. But this is a case where the court is being asked to change precedent. If we go all the way back to the beginning, little section. This case requires us to address for the second time in a decade and a half whether it's permissible to execute children. A divided court in Stanford, just 16 years prior, rejected this proposition, and we are reconsidering the question. So we know that the court is being asked to change the law. Issue, factual background, rule or current law, this is what the law currently is, and should we change it? That is the analysis or the application section. And if you are looking at this and if you're looking at your brief and you are not seeing a why or a how or anything about why the precedent changed, it's because it's difficult to understand that this is the analysis section. So let's dig into it. 3A talks about when states could execute people, and this opinion uses the word mentally retarded. We don't use that word anymore, but historically the law is kind of full of words we don't use anymore. So let's say mentally disabled. The court looked at a situation involving the Penry case and said, in Penry, we said it was perfectly fine to execute mentally handicapped people. 3A talks about all of the states that refused to do so. So what do you suppose 3B does? 3B looks at the exact same thing in terms of juveniles. So we had Stanford that said you can constitutionally execute 16 and 17-year-olds. 3B goes into all of the states that didn't do that. So this is the analysis section. This is the why. This is the why the court is coming to the conclusion that no, it's not okay. A, because even though Penry said we could execute mentally challenged individuals, states didn't. B, and a majority of states have rejected it for juveniles. Now we're going into 4. I would argue to you that from a legal writing perspective, 4 could have been C, because the court could have organized 3A is a national consensus on mentally challenged individuals, 3B is a national consensus on death penalty, C is a worldwide consensus. But instead, from an organizational standpoint, they chose to look at 3A, they chose to put all the national consensus stuff in 3, and then the global consensus argument. How do other countries treat this argument in 4? There's a reason. All of this here in 3A and 3B about how states ruled, majority of states have rejected, that is more persuasive than what a different country does. how states react in a situation where the Constitution gives us the floor and states give us the ceiling. That's much more persuasive on a court than what, oh, I don't know, Denmark does or another country does. Doesn't mean that we're not going to talk about it, and it did convince this court, or at least was part of the underpinnings of their argument. But here in 4, the stark reality that the United States is the only country in the world that allows this. And 4 just goes on to detail what the policies were across the country, across the world, rather. And then it also talks about amici, which is amicus curiae opinions. I'll show you where that is. As respondent, Simmons, and a number of amici emphasize. Amicus curiae means friend of the court. Every time there's a large Supreme Court decision, specifically on constitutional matters, that comes down. Interest groups from around the country can write a brief to the Supreme Court that says, oh, well, we're not parties to the case. We don't have standing to litigate this. We don't have a dog in this fight. But we're very interested in it. So an amici, an amicus curiae organization might be Amnesty International. They are an anti-death penalty organization. In a civil rights case, maybe the ACLU might be an amicus curiae. Interest groups, policy groups that have an interest in the topic of the litigation may be allowed to write an amicus curiae brief. So this 4 section is saying, here's what the rest of the world does. We're an outlier. And our amicus briefs showed us that in detail, talked about all of these other countries. Here are the countries that allowed it: Iran, Pakistan, Saudi Arabia, etc. Recently in the UK it was abolished, and there is our conclusion. So the conclusion probably should be in a 5, should be in a separate section. I would put a 5 there, but I'm not a Supreme Court justice. So here we have the conclusion right at the end. The 8th, 14th Amendments forbid imposition of the death penalty. Now you should be able to see that the court itself uses IRAC formation when they organize their briefs, and they do it for the entire thing. They'll also do it in sub-arguments, and they'll do it in subsections. The only other thing I'm going to show you is I'm going to go specifically in detail on a couple of things. And I don't need to do that on the facts because the facts just are what they are. And you can read what happened in terms of his age, his crime, what he was charged with. State sought the death penalty. As you read this and as you write, pay attention to topic sentences. They are invaluable to you because as we get into the analysis in sections 2 and 3, 2 where the rule is, 3 and 4 really where the analysis are, those topic sentences will help you understand what's going on here. Here's what happened during sentencing, death penalty, tried to get a new attorney, blah, blah, blah. We don't need any of that. Number 2, section 2 tells us what the law is. You can tell that by looking at the topic sentences in 2. The 8th Amendment provides, here's what the 8th Amendment, here's the 8th Amendment. All this entire paragraph is what the 8th Amendment is. This paragraph is what the term cruel and unusual punishment means. That's it. 3rd paragraph, in Thompson, here's what we did. Do you see if you take it slow and you read it again, every topic sentence is pointing out what the court is doing. It's all rule through the entire 2. They aren't going to analyze. They aren't going to explain. They're just going to tell what the rule is. Here's what we did in Thompson. No under 16. This 2nd section talks about why Thompson did what it did. Next paragraph, here, let's talk about Stanford. So these 3 paragraphs say, in 1988, we decided no to below 16, and here's why. 1989, we said it's okay for 16 and 17-year-olds. Now, you could put a break in here in terms of your understanding. Let's take a look at this paragraph right here. Same day, the court decided Stanford. Stanford said it's okay to execute 16 and 17-year-olds. It also held that it was still constitutional to execute mentally challenged individuals. The very next paragraph, we changed our mind in Atkins. Now do you see why the court relied so heavily on Atkins? It was able to say, the same day you decided Stanford, you decided Penry. So it's perfectly fine to execute children as well as mentally challenged individuals. But 3 terms ago, so court terms, so months ago, just months, not years, we changed our mind and said it's no longer constitutionally permissible to execute the mentally challenged. That was an invitation to overturn Stanford because they were decided on the same day, and the court's rationale here went on to apply Atkins and the rationale in Atkins to Stanford. This court then explained essentially why Atkins changed the Penry precedent, because of the 8th Amendment, because of the national consensus. Just as the Atkins court reconsidered the issue decided in Penry, we now reconsider the issue decided in Stanford. This is ending their rule section, and it's essentially just a minute to say the same day that Stanford was decided, Penry was decided. We've already gone back on Penry. Now we're being asked to go back on Stanford. We are ending our rule section here. Now we get into 3A. Here's our analysis section. Here's where the court goes into why they are ruling in Simmons's favor. If you have a hard time understanding why this is the analysis section, I encourage you to read the issue first and then go all the way down to the opinion and read the holding. It's how I read and it's how I write. I know that the court decided, no, it's not constitutional. If I know that first, before I go into the explanation of why it's no, I have that in my head when I read this opinion. The evidence of national consensus against the death penalty for juveniles is similar and in some respects parallel to Atkins. Here they are going through and saying why we are changing our mind on juveniles. That's the end of 2. Atkins reconsidered Penry. Now we're being asked to reconsider Stanford. Here's why we are reconsidering Stanford and saying no to Stanford. It's unconstitutional. Because the way states treated juveniles is the same way states treated the mentally challenged between the Penry decision and the Atkins decision. So the court is saying here, Penry and Stanford same day. Penry says, perfectly okay, constitutional to execute mentally challenged individuals. States largely said no. That was used in Atkins to overturn Penry. This section talks about all of that, talks about all of the states. And they use specific examples too. Governor of Kentucky decided to spare this guy's life because he, quote, legally was a child. Talk about a little bit of difference because the rate that states changed their laws in response to Penry was not the same as the rate in Stanford. That's a smaller issue. And that's all this section is doing, is that it's going over the history of what states did in relation to Stanford and comparing it to what states did in relation to Penry and making the argument that we should do the same thing. Now we're looking specifically at what states did, rejecting the imposition of the death penalty on juvenile offenders after Stanford, and it just goes into detail. If you read this in detail, it's these same things. Now here's where we go into the why. Juveniles are not reliable, scientific and sociological studies. That is what draws our eye, and for many of you, if you look at your briefs, I guarantee you there's a section that, well, kids just aren't as mature, whatever factually. That must be and is only relevant in terms of this. So this is a lesson in focusing on the law and why the facts underpin the law as opposed to the facts are important. It wasn't so important, or it isn't so important, that juveniles are immature. What's important is that a majority of states reject the death penalty on juvenile offenders because they are immature. Focus on the law. And when you use these topic sentences to guide what the court is saying legally as opposed to factually, it really does help you understand the case. And then this is how we will write when we write to represent our clients next. Okay. This just goes on in more detail to talk about the national consensus about juveniles, and it makes an argument about we are comparing what happened in this country with juvenile capital punishment to adult capital punishment of mentally challenged individuals. That's all this is doing, and it's all analysis. Then all 4 does is it comes on and it adds another analytical piece and says, oh, by the way, we are the only country in the world really that does this, and we probably shouldn't. And then it concludes. So the analysis of this court case is important. And if you want to write an analysis section and shoot it to me, we'll take a look at it, or we'll keep talking about it in class. Why the court went back on precedent matters here. And that issue, that analysis is important. Let's pretend for a minute that you have a client and he is a substance abuser and has been under substance abuse care for a long period of time. It is perfectly constitutional currently to execute him for homicide. Now, if we were able to use this case and compare him to a juvenile or compare him to a mentally challenged individual by using all of this analysis here, and if we could point to multiple states who currently have the ability to execute substance abuse offenders. Majority of states have rejected the imposition of the death penalty on juvenile offenders. What if we had a bunch of states that have rejected the imposition of the death penalty on people who were chronic substance abusers? That's why the analysis matters, because then we could point to our substance abuser and say it is unconstitutional. Not we shouldn't, but that it is unconstitutional to execute him because he is no different from a juvenile offender or a mentally ill person. And states all over are not allowing it. There's no national consensus that it's acceptable. Therefore, don't execute my client. This is important because once you understand the rationale of this case, you can apply the rationale of this case to your client's case in an effort to represent your client in the exact same way. If you have any questions on this, shoot me an email.